So let me first quickly introduce myself. Some of you may not know me. So my name is Daksh Mitra, and I work with IMS as Chief Mentor for undergraduate courses. And I am a lawyer myself from National Law University, Raipur, HNLU Raipur. And I've been training and mentoring students for the past 5.5 years with law entrance exams. Uh, what we are here for today is basically an event under IMS Get Set Law banner. So all of you are aware of the IMS Get Set Law activities that we have been doing. So we are, one of the leading entrance prep companies out there for helping students prepare for various entrance exams for law, whether it's CLAT, MHCT, ALAT, Symbiosis, and we have had a fantastic success rate in all these exams year on year. So we are called IMS, but we have given ourselves a new identity for specially running our flagship the law entrance program, and for that we are now called IMS Get Set Law, so GSL. Now, as a part of IMS Get Set Law, we have been doing a lot of activities for law aspirant community across India. And this has been received very well so far by the audience. We've been calling legal experts from diverse fields of law, people who are working in corporate law, IPR, people who are practicing in the Supreme Court, High Courts. So we have been calling them to address students of CLAT, basically those who are aspiring for a career in law. We've also been having students from sessions on Insight, in which we get students who are studying at top law colleges in India, and they come and discuss about their campus life and how is basically their life at various top colleges. IMS Get Set Law is a platform to bring all law aspirant community together. So I would highly recommend you to hit the subscribe button and stay updated with all the events that are happening at IMS. So this is our official channel, IMS Get Set Law. Do hit the subscribe button. Apart from this, we also have a Telegram group called IMS Get Set Law, IMS GSL. So open the Telegram app and just search for IMS Get Set Law. On that channel, anyone can subscribe and stay updated with everything that is happening on this platform, right? So thank you so much for being here tonight with us. Today's session basically is one of such sessions in this series wherein uh, we have invited a guest professor, a guest lecturer from Symbiosis Law School Pune. She's a very good friend of mine, and both of us have finished our law together from HNLU Raipur. We were batchmates, we were very good friends, and now she's working with Symbiosis Law School Pune as assistant professor. So her name is Miss Garima Panwar. I would like you all to just welcome her and I along with you all look forward to this session from her. Probably this is the first time I'm seeing her as a teacher myself. Whenever we have interacted before, it's always been just like friends, but this is the first time we have associated together formally. So it's a new experience for me also. So Garima here will be taking a class for you on criminal law, and she's going to cover a topic which some of you might be aware of. We have covered in our classes also, but we didn't go too much into detail of it because it's a difficult topic to understand, and I'm sure that Garima will be able to explain it to you in a very clear and a concise way, and you'll be able to understand this concept better, which is the concept of culpable homicide amounting to murder versus not amounting to murder. So what are the difference in the ingredients? But before we get on to that, I just wanted to have a quick discussion with Garima about her journey in the field of academics. So, a lot of law graduates today take up a career as a law professor. They want to be a teacher at a law school and pass on their information to young generations. So why not just hear it from her side? How has her journey been, and where did she start off? How did she land here? And maybe after that we can start with the criminal law class. So Garima, welcome once again on behalf of IMS GSL Law. Thank you so much for being
Thank
here.
you, Daksh. Thank you so much.
So students are looking forward to a class from you. Before we begin, so Garima, can you tell us a little bit about yourself and your journey so far? How did you get into law? How did you get into law school? And how did you get into the field of academics?
Okay, so starting with, like you have already introduced me, that I was a batchmate from Hidayatullah National Law University, Raipur. So I gave my CLAT way back in 2009. I couldn't clear in the first attempt, so I again gave that in 2010, and I joined HNLU Raipur.
Mhm.
Thereafter, I was a bit confused till my third year as to what exactly should I do, because I saw that most of the students who have joined over there, they were there for some law firm job as a legal counsel, or for a corporate job. But for me, after my third year, I realized that teaching is my passion. And how did I realize that? When I was teaching my friends and other friends who were there, even while I was interning, I used to teach a lot of them. So from there, I got motivated, and I thought that this is my passion and I should pursue my passion. And
Mhm.
thereafter, when I realized in third year onwards, I started preparing for the second CLAT, because for post graduation exam also you need to give a CLAT, and then you are again allotted with the colleges. So in
Mhm.
2015, I gave my my third CLAT technically, for and for post graduation, I did my post graduation in intellectual property rights from Nalsar, Hyderabad. And thereafter the journey started. And for the first teaching experience, I was there at Nirma University, and over there I was teaching the engineering students. So it was altogether a different experience teaching non-law students. And then finally I joined Symbiosis Law School Pune.
Mhm.
And progressing further, like this year, starting of this year, I also got an opportunity to teach at Berlin School of Economics and Law, Germany. So that was a great experience over there. So that's how the journey has proceeded.
Mhm. And I believe that you also cracked the NET exam, UGC NET, right?
Yes, yes. So
So
immediate.
how was that? How difficult was it to crack NET? And is it really required for you to become a professor to first crack the NET exam?
Yes, yes. So it's like after clearing your post graduation exam, if you want to enter into the teaching field or the academics field, then you need to clear NET exam. It's a
Mhm.
national entrance test, and once you clear that particular entrance test, you
Mhm.
will be eligible to teach in university, and you will be first recruited on the post of assistant professor. And I
Mhm.
cleared in 2017, and I am NET JRF. It's Junior Research Fellowship. So the top 10% or 15% students from all over India gets this fellowship. And if they want
Mhm.
to pursue full-time PhD, government will be giving them funds for pursuing their PhD on the topic they choose. So I'm currently pursuing PhD, not a full-time PhD. I'm not using my JRF, but still I'm a JRF. So it is, yes, a difficult exam to crack on, and it's
Mhm.
not easy to clear in one go this particular exam, and it involves multiple subjects, and there are analytical based questions. There are few questions which are many times rattafying type of questions,
Mhm.
but at the end it gets cleared.
Right. And how is it? How has your journey been so far at Symbiosis Law School as a professor? How is it like being on the other side? First being a student of law and then now being a professor of law. So could you share something about that?
Yes, yes. Being a professor in law, now I can understand how, as a student, many times we did not understand what exactly the professors are going through when they are teaching us, or when, especially, I'm realizing this when we are teaching through online mode.
Mhm.
And other things are, students at Symbiosis, they are challenging in the sense they challenge you every time to read more, to get prepared, and to solve queries every time. So there's constant interaction between the students. They ask it's basic doubts, so you have to clear from the inceptions. And I teach first years also, I teach LLM also. So when I'm teaching first years, I could figure out that they're naive kids. They need to be brushed up from the inception and then progressing gradually.
Right.
That's how the experience has been.
Awesome, awesome, awesome. And I believe the classes even for you is are going online right now, correct? Because of
Yes,
the.
yes.
Mhm.
All the classes are going
So,
online. Even mood codes, everything is going online.
so how has the transition been for the law school and for you and the students to this new way of learning at law school?
Initially, it was a bit difficult because it was like a surprise for all of us
Mhm.
that we are thrown for the lockdown and we are being asked to complete our syllabus, because it was there in March and we complete a session in April. So we were
Mhm.
asked to complete a session
Mhm.
in March and April through online mode. It was difficult for the students, especially when they are submitting the assignments and we are conducting vivas for the whole day. So it's hectic both ways.
Mhm.
But now students and faculties both have made this as a way of life. The only negative point which I feel like is the physical interactions which I have with my students in college, and drawing on the whiteboard and
Mhm.
explaining things.
Yeah.
That's the only thing which is lacking. Otherwise, yes, it's
Mhm.
going good.
Great, great, great. But we all hope that this gets over very soon and we go back to our normal physical classes and everything. All
Yes.
right. So I think that's a very good insight about the career in academics and all of you students. So we will be having some Q&A from you also. We'll of course take questions from you also towards the end of today's session. But I will now ask Garima ma'am to take up the topic for today, that is criminal law. And I would request everyone to stay on till the end. We'll try to squeeze in a Q&A towards the end of the session. Aditya sir will be here along with both of us. So Aditya sir will also be helping with the queries on the chat box. Aditya Shekhar sir, who's also from NLU Jodhpur, and he'll be concluding the session today along with Garima ma'am. So please stay on till the end, and in case you have any queries, drop them in the chat box. And those of you who are not IMS students and you wish to know more about IMS programs, you can also stay on till the end. We'll tell you how to reach us on various modes of communication with us. And please do subscribe to this channel and to our Telegram channel to stay updated with latest events. Right. So thank you so much. I'm giving the stage to Garima ma'am from here on. Uh, please go ahead. Thank you.
I'll share my screen.
Yeah, yeah, please.
Okay, is my screen visible?
Yes, it is visible.
Okay, okay. So, we are starting today with the topic of culpable homicide and murder. What's the difference? Is there actually a difference between both these concepts? So, we'll first start with the basic thing. Basic in the sense, what exactly is homicide? So, when I'm teaching you today, I will not just restrict myself to, like, I'm teaching law student or an aspiring law student, but I will be also teaching you how do you read a bare provision or a bare act. Bare act, I'm referring to the IPC code, that the Indian Penal Code. So that's why we will refer provision by provision. So be there with me, and also if you all want, you can also open your Bear Act. If you don't know what's a Bear Act is wherein all the provisions are like all the law provisions are given. So just Google IPC PDF, Indian Penal Code PDF, you will get one, and we can go side by side. Okay, starting with homicide is, what exactly is homicide? So we divide this particular work. So we'll divide like homi and side. So homi like Homo sapiens, so and side is like killing. So when a human being is being killed, we call that as homicide. Now, when we refer to the Indian Penal Code, the categorization as to what exactly is punishable, what is not punishable, it all depends on the degree of a particular intention, what a party is intending in his mind, or the knowledge of that party, that whatever act he or she is doing, is it doing with the knowledge that he might kill the other party? Or what is the degree of recklessness? Now, recklessness means carelessness, how careless a person is while he's acting in a particular manner. So we are categorizing different types of homicides on the basis of these degrees. So after explaining this, so homicide, don't go now into what's culpable homicide and murder. We will go at the future point of time. But what we have to refer is that there are certain homicides. Like, remember what is homicide? Homicide is killing a human being. So there are certain homicides which are lawful. Lawful in the sense, the law says it's okay if you kill this person. If it's okay if you have killed, or you have a person has died because of you or because of your act. Now, when we say it's okay, so it's okay, how do we judge? So is that your discretion? No, it's not your discretion. You are figuring this out by the exceptions which are given under Indian Penal Code. So what are the exceptions? So if you open your Bear Act, there is a chapter which is called as Chapter 4, General Exception. I'm writing over here, so if anyone is noting, so this is Chapter 4, and this Chapter 4 gives down a list of exceptions, wherein if at all you have committed an offense, if because of your act a hurt has been caused, or the other person has died, then that will be totally exempted. You will not be held liable for the same. I hope you understand the meaning of liable. Liable, that you will not be punished under law. So when we are saying that there are certain homicides which are lawful, it means that there are certain excusable and certain justifiable homicide for which you will not be punished, or you will not be punished in the eyes of law. Now, examples. For example, I'll just take example of Daksh, and over here there is a person, Aditya. I'm so sorry, I'm taking your names. So Daksh and Aditya. So over here, Daksh goes to Aditya and he goes with a hammer in his hand. If you remember Patar Lok serial, so Daksh goes with a hammer in his hand and he's about to kill Aditya, and Aditya is shocked that he's about to be killed. So what he does, he picks a big stone and he throws at Daksh. So over here, what we are referring to, if Aditya is acting in a certain manner because he knows he's about to be killed, so this is called as private defense, that I am defending my body. And while defending my body, if I kill someone, like Aditya is killing Daksh by throwing a huge rock on Daksh, so this will be justified. Why will this be justified? Because he is defending himself. He is defending, Aditya is defending his body. So we call it that these kinds of homicides are lawful if that's with the you're defending your own body. Yes, like many of you are writing on your charts that it's a self-defense thing. It's called as a self-defense in layman language, and otherwise, if you legally speak, it's called private defense. So there are many excusable or lawful homicide. Just refer to chapter 4 whenever you get time. You will get a list of all the lawful or justified homicides. Not talking about unlawful thing. Now, unlawful homicide is which is prohibited by law. Now, when we are saying that this is prohibited by law, it means that this is not allowed under law. And if you commit such act or omission, remember, I'm using both words, act and omission. So if you are acting in a certain manner, or if you're omitting to act in a certain manner, then this unlawful homicide will be happening if it's falling under the various provisions of IPC. Now, when we are saying it's unlawful, it means a person will be held liable. A person will be held liable in the sense, a person, if we take this word liable, there is a synonym for liable which is called as culpable. So that's how we derive and we merge these two words, that is homicide and culpable. That is a kind of homicide wherein you will be held as liable. I hope you understood this. So we will proceed to, when we have mixed these two terms, culpable and homicide, we will proceed how culpable homicide is related to murder. How do we think that these two things are different or same? So there's a common saying which says that culpable homicide is a genus and murder is its species. And there's other saying which says that all murder is culpable homicide, but not vice versa. Why have I pointed out to these two questions, these two statements? Because when you will all will be appearing for all the competitive exam like CLAT, SLAT, in the statements, like there are questions relating to statement and arguments. These kinds of statements are often put forth, and there we are lost as to how do you relate this with the facts. So we'll understand this particular concept as to why are we calling culpable homicide as a genus and murder as a species of this culpable homicide, and what is the meaning of this. So we'll understand with the help of Venn diagram, and you should know what a Venn diagram is. So we are saying that culpable homicide is a broad term, and in this broad term, murder is one of the subsets. So that is why, because always remember this Venn diagram, it says that all murders are culpable homicide. All murders are culpable homicide, but all culpable homicides are not murders. So there are certain culpable homicide. Culpable, I'm telling you again, culpable is liable and homicide is killing a man. Now, how exactly is it defined? Killing a man means both man and woman. We won't go into that argument. But culpable homicide, we'll be discussing about the definition later on. But over here, we are saying that there are certain kinds of homicide which are not considered as murder. So we will proceed further and we will discuss as to what exactly is this culpable homicide amounting to murder and not amounting to murder. Okay. So many of you must have heard that all these culpable homicide and murder are there under section 299 and 300. So that you do for ratification. But we will now discuss point by point and with example. Like one of you have put that in the chat that ma'am, please give example. I'll definitely give examples. Without that, I can't teach. So culpable homicide, we have to divide in two parts. That there are certain culpable homicide which are called as murder. That's why we say culpable homicide amounting to murder. And there are culpable homicide which are not amounting to murder. And we have categorized. So one thing you notice in this particular segregation, I have not mentioned section 299, like segregation of amounting to murder and not amounting to murder is there under section 300, and not amounting to murder is the exception 1 to 5 of this particular section 300. So what are these section about? We'll start this. So what exactly will I be teaching you today? I hope I'll get sufficient time. So we'll start with section 299 as to what exactly is culpable homicide. Then we'll go to what is murder. And then we will go into the definitions and also what exactly is the exceptions under section 300, and finally the distinction between both of them. So starting with the meaning of section, the meaning given of culpable homicide under section 299. Remember one thing, section 299 is merely defining culpable homicide. It is not saying that this will be called as an offense, or it's not explaining in general that whether this is murder or not amounting to murder. Nowhere over this section, if you open, it says this amounts to murder, this does not amount to murder. Okay? So section 299 is merely explaining or merely defining what do you consider as culpable homicide. And the first, I'll read the bare act and then I'll give explanation for each and every heading. So it says, whosoever causes death by doing an act. So when we are using this particular word act, act also means omission. Omission wherein there was a duty on your part to do that particular act, but you omitted yourself from doing that particular act. So there's an act, and because of your act, one person has died. There's a death which is caused of one person. Now, the three headings which are given below now, we will be interpreting now. Yes, section 299 of Indian Penal Code that we are discussing. So, whoever causes death by doing an act with intention of causing death. Second, it says the word uses or, with the intention of causing such bodily injury as is likely to cause death. And third is with the knowledge that he is likely by such act to cause death. Now over here, what we have noticed that in the first two headings, the word intention is being used. It over here, it means that there is a direct intention to kill a person. For example, we will take an example. This is a person named X and there's another person named Y. Now X and Y, they are enemies, and as soon as X sees Y, X takes out his bullet and shoots at Y, and Y dies over there. So there is death of a person, there is an act by whom? By this person named X, and also X is having an intention. When he's taking out his gun and he's pinpointing at Y, it means that he wants to put that particular person to death. So there's an intention to cause death. Then we have is with the intention of causing such bodily injury as is likely to cause death. So when we are saying that there might be such bodily injury to the other person, that there is a possibility, the word, what is the word used over here, is likely to cause. So there is a possibility that the other person might die because of the injury that you have inflicted. So for example, we'll again take this X and Y situation. X has a rod in his hand, an iron rod in his hand, and he goes to Y and he hits on his head, and because of which he faints, and after a few days he dies. So when he is hitting him on the head, there's a bodily injury. There's an injury, and there's a possibility that this Y person might die because of the other person's act. So this is, we call it, there is an injury, and because of this injury, it is likely to cause the death of the other party. Now talking about the knowledge. Now there's often confusion as to what is intention and knowledge. Is there a difference between them? As such, if you say intention is of a higher degree and knowledge is a bit lesser, but still we are considering, when we are considering this culpable homicide, the whole difference between amounting to murder and not amounting to murder, these two things, that is intention and knowledge, do play a vital role in the interpretation. Now coming to the question of knowledge. Now, knowledge or the example, it says that with the knowledge that he is likely by such act to cause death. Likely in the sense, for example, um, there is, I'll give some other example. So there is a person named A, and this person digs a huge pit under the ground, and then he covers this pit with leaves so that no one sees this particular pit. Now what he does, he asks B that would you like to come on this particular ground, I want to meet. What was A's intention? That the moment B comes, B falls into this. So over here, if A with an intention to kill B, to kill B, he digs this particular pit and then covers it so that B doesn't know. And as soon as he hops in on this particular ground, he gets inside this pit. So this particular A has a knowledge that there is a possibility that if this person B falls in this pit, he might die, because A had the length of the pit or some other consideration of the facts which are there might be such that this person might die in a few situations. So this is the element of knowledge when we are considering the homicide part, the culpable homicide part. Now, after this, if you go further, there are many explanations which are given. Now, if you open your Bare Act, and there are 3 explanations which are given under section 299. All these explanations are with respect to death. How the death is caused, when a particular death is caused, only with respect to death. Nowhere in this explanation is the legislation clarifying or pinpointing that whether this is culpable homicide amounting to murder or not amounting to murder or any other offense. So it is just highlighting upon the death of a party. So when we are discussing about this, we'll start with the first explanation. I'll give the examples of the explanation so that it becomes easier for you. So we take the example. There are many students who are messaging. I'll take their name only. So there is this person, Arya, and there is another person named Jet. Okay? So these 2 persons are there, and Arya knows that J has recently undergone a surgery, and because of the surgery, he is not able to move his hand, and the doctors have asked J to rest, and if he doesn't rest, then and if he exerts much, then there's a possibility of a risk to his life. So what I'll read the explanation now. I hope the facts are clear now. So I'll read the explanation and then relate to the facts. So the explanation says that a person who causes bodily injury to another, who is laboring under a disorder, disease, bodily infirmity, and thereby accelerates the death of the other, shall be deemed to have caused his death. So what we are saying, if Arya is aware that J might die if he is being subjected to more torture, or if he is subjected to some physical injury. So if subjecting of this particular injury to J will is actually done, and because of this J dies. So what we say, that the bodily injury or the disease, or what we say is the infirmity or disorder which was existing in the victim, only aggravated. But why did it aggravate? It aggravated because of a person's act. So over here, we can say that it was because of Arya's act, J's disorder or deformity or disease that aggravated. Now, even though we can say that J died because of a particular problem in the hand, or he died of a particular disease, but that act of Arya accelerated or increased the propensity of death of J. Okay? So this is also called as death. Then the second thing that we take is um, where the death is caused by bodily injury. The person who causes such bodily injury shall be deemed to have caused death, although by resorting to proper remedies or skillful treatment, the death might have been prevented. So, for example, we will take Salman Bhai. Okay? No offense to anyone. So, we'll take this example. Okay? We'll take Salman Khan. He is driving a car. Okay? And while he's driving a car, he went over a few pedestrians who were there, who were sleeping at night. So over here, Salman Khan drew over the pedestrian, and afterwards, he just went from there. Later on, if this person is brought before the court and he says that when I drove my car over these pedestrians, they were still alive. There were many other pedestrians who were looking on the persons who were rushed under my car. They could have taken them to the hospitals. So it's their fault because they were not given proper medical facilities. They died. It's not because of my fault. So what this explanation is saying, this explanation 2 is saying that if proper medical remedies are not provided with, proper, skillful, timely medical facilities are not provided with, and a person dies, then it's not a consideration that you have to see. What you have to see is whether your act was such that it's likely to cause death. So this is you consider with respect to explanation 2. Now going to explanation 3. I'm so sorry if I'm rushing too much. Now going to explanation 3. Now explanation 3, there's a person named X. She is delivering a child. Now when she is delivering a child, she is undergoing labor. Now, at that time, there is Y. We will call her as mother-in-law. What she does, she kills that child. Over there, if a child is killed in the womb, okay, there's no childbirth, not even one single part of the child has been delivered, it has come out of the womb. So if a particular child is killed in the womb, then that person, if Y is killing child in the womb, that Y will not be held liable for death of X as culpable homicide. Why not culpable homicide? Because we are saying culpable homicide. Homicide, when we are saying human being. So it is presumed under law that unless and until a person is actually born, person will be only given protection under this culpable homicide concept. So that person will be considered as a person in a legal sense. So if a child is killed in a womb, that person, that particular act of killing will fall under the definitions, the provisions from section 312 to 316 of the Indian Penal Code. But if a hand comes out, or if a certain part of the child comes out, or we say that even though half of the body of child comes out and the child is not breathing, but still you attempt to kill that person. So it's irrespective of the fact whether the child is breathing or not, or whether the full childbirth has happened or not, then this particular act of putting to death this particular child will be called as culpable homicide. But if it's there, the child is there in the womb, it will not be called as culpable homicide. I hope it was clear for you. You can read explanation 3 for the same. Now, why, like one of the question is why would Y be liable? Because it was Y's act. Like mother-in-law was like, let's kill this baby which is coming out. So if she kills the baby in the womb, she will be held liable under section 312 to 316 of IPC. But if the baby is out, even if a small finger is also out, and then if she tries to kill, then and that baby is killed finally, then this person Y will be held liable for the death. So this is the sections which are dealing with culpable homicide and the explanations thereon. So we will proceed now to section 300. Now the table which I have drawn, many times the law students confuse that this table means that this is reflecting upon the difference. This is actually not reflecting upon the difference. It is pointing to the fact that how section 299 is corresponding to section 300. Section 299 in the sense that, remember I told you that culpable homicide is a broad term and murder is a subset or a species of culpable homicide. So now we are narrowing down. While now we are from culpable homicide, we are narrowing it down to murder, and we are showing as to how aggravated a culpable homicide should be in order to amount to murder. Now we start with the examples, but before going to examples, we will start with the concept of section 299. Section 299 and section 300. Section 300, one thing, if you open your Bare Act of Indian Penal Code, it says except which have been provided below. So it says that the 4 headings which are provided under section 300, firstly, secondly, thirdly, and fourthly. Open your Bare Act if you can. These 4 headings which are mentioned, these 4 headings will amount to murder. Except these 4 headings, if any one of them is fulfilled, the remaining which are there, everything will be falling under culpable homicide, not amounting to murder. So what we are doing now, what I said is, the section 300, the 4 acts which are specified initially, which I'll be just discussing, they will be called as culpable homicide amounting to murder. Why are we segregating? Because on the basis of this segregation, the amount of punishment will be determined. So we are saying that this particular murder, this person, if there's a murder committed, it will fall in 4 of the acts which are there. And if it falls under any of the exceptions, under section 300, then it will be culpable homicide, not amounting to murder. Now, how do we categorize this particular thing? We will study, and a few of the examples I already gave for culpable homicide, and now we'll draw a difference between both of them. So starting with the first heading, which it's discussing under murder, it says if there's an act by which death is done with the intention of causing death. So if you see this section 299 clause A and over here clause 1, these two are same. So never get confused in these things. In section 299, we just discussed culpable homicide. Nowhere was it mentioned it is amounting or not amounting to murder. And because culpable homicide is like murder is a subset of culpable homicide, that's why we are saying the first heading remains the same. That is, there's an intention of causing death. Like I gave an example, X shoots Y at gunpoint. So there's an intention of causing death. And how did we construe this intention? So for your knowledge, I hope many of you must be knowing, whenever a matter goes to the court, in order to judge the intention, in order to judge the knowledge, there are many also to determine many facts, there are many evidences which are given before the court, and if a person fails to furnish that particular evidence, then the person is free. So it's always, everything in criminal law, it's based on evidence, whether you are able to furnish evidence or not. Now, this whole evidence thing is covered under the Evidence Act. What kind of evidences will be covered? But still, when we are referring to an intention, there are many means of determining a person's intentions. Like, for example, I am very angry today with my sister that she did not feed me good food. So what I do, I take one axe and I just throw at her. So I know that I had the intention. Why? There was a presumption that I had an intention to kill my sister, because the act which I was doing, that is the act of picking an axe and pointing out to my sister and then killing her, that's actually showing the intention that it was there in my mind, and that intention is actually reflected. So that's an intention to cause death. Now, when we are referring to clause B of section 299, this clause B corresponds with clause 2 and clause 3. Why does it corresponds? I'll explain now. See, section 299 clause B, it talks about bodily injury, intention of causing bodily injury as is likely to cause death. Whereas this clause 2 and 3 of section 300, these two also talks about bodily injury. Okay, so this is the common point between clause B and clause 2 and 3 of section 300. Now, talking further, how section 300 is aggravated form of 299. So section 299 was talking about intention of causing bodily injury. So if you have forgotten, I gave the example of the like A digging a huge pit for the other person, so that he falls and he might injure himself. So over here, if there is an intention of causing a bodily injury, that it is likely to cause death. The word used is likely, that there's a probability that a person might die or might not die. Over here, when we are going to section 300, it says that with the intention of causing such bodily injury, and a person knows that it is likely to cause injury. So what we are doing in this clause 2, we are using both words, that is intention also and knowledge also. So if both things are present, like intention is also there, knowledge also there, and the person knows that this person will definitely die because of this. So over here, we say that this will amount to murder. I gave you an example just before that through one of the illustrations of Arya and Jay. In the chat box, they're saying Jay is already dead. So the in the example of Arya and Jay, where Arya is inflicting injury to Jay with an intention that he dies. So this is an intention. But Arya knows that my intention will definitely lead to Jay's death, because he's suffering from this injury and he will die there and then. So there's an intention also, there's a knowledge also. I'll give you another example. Another example can be, for example, there's a person who is suffering from brain hemorrhage. And I know that that person is suffering from brain hemorrhage, and I want to kill that particular person. Then I will hit that person on the same spot. That person will definitely die. Why? Because I had the knowledge that this person is going to die if I hit on this particular part. So there's an intention to kill and there's also knowledge to kill. So in murder, you combine both of these. Whereas if you check just the culpable homicide thing, it was only intention. So this was the example of the clause 2. Now, but clause 3 is with the intention of causing bodily injury to any person and bodily injury intended to be inflicted is sufficient in the ordinary course of death. Now, I know you're not the pro law students, but still there's always a need that while you're solving your CLAT papers or your SLAT papers, always read these lines properly, because the hints lies in these kinds of provisions only. So this particular provision, it says that there's a bodily injury, and the bodily injury is such that in all probability there will be death of the other party. So for example, I am like I am attacking a person and I'm taking a talwar with me. I hope you know what's a talwar. So I take a sword with me and I just hit the other person. So I am using the weapon sword, and that weapon in ordinary course, a person will die. Because so there is always a presumption, and who is making that presumption? A reasonable person who is there, that in a reasonable situation, if a person is using a sword, in all probability, if a person is hit by a sword, that person will be dying. Or if you, I'll give you another example. If you are following the latest case, a few days back, which came out by CBI, Sister Adya's case, wherein she was attacked by axe. So axe, the weapon is such that in the ordinary course, a person will die. So whether it's there in a head or a neck or wherever it is, whether if it's there in the vital part, then the person will definitely die. So bodily injury is there, plus the intention is such that in all probability a person will die. So how did I compare to the culpable homicide one? The word used over there was likely, and whereas the word used over here is in ordinary course of nature, it is sufficient to cause that. मरेगा ही बच्चा, ठीक है? अब now we proceed to the, for I don't have much time left. It's till 10. I have to rush through. I'm so sorry. Okay, so section 299, it says that with the knowledge that the act is likely to cause death, and we compare the same to the knowledge that it is imminently dangerous, that in all probability the death will be caused, or the person will be inflicted to such bodily injury that this bodily injury in turn will lead to the death of the party. And there will be no excuse, like a person cannot take an excuse that he only came and took the risk. So what, I'll give you an example for this. For example, remember the pit example, that B came and fell into the pit. There is a possibility, there's a likelihood that B will die in falling into the pit. It's not for sure. But what if I put nails and swords inside that pit? So if B comes and falls into the pit, definitely he will die. Okay? So in all probability, the death will be caused. Another example. Now, usually this clause 4 is not much in practice, but still these cases, if you refer the illustrations also, these are relating to the concept like if a bomb is thrown on the crowd, and in all probability someone will die, or I want to kill a particular villager, so I'll just put poison in the well, and so that everyone consumes and everyone dies. Or I fire a loaded gun. I fire loaded, like you must have seen in many of the newspapers that during Shadi season and all, people fire guns in the air and at the end someone dies. Or there are times when people fire in crowds. So in all these cases, there's a presumption that a person has a knowledge that death will be caused. So what is a certain result for the same? Death. Now, coming to, this was all culpable homicide amounting to murder. All these 4 clauses. Now, what is not amounting to murder? Now, not amounting to murder is, okay, one of the question is euthanasia a murder? Okay, read the latest judgments which are there on this particular case or on this particular subject matter, that passive euthanasia is allowed and not active euthanasia. So if we will consider this euthanasia part in the consent part in the last exception. If you are there in the chat, do remind me again while I am discussing about the exception number 5 about this euthanasia. I'll refer you over there. Okay, coming back to this. Coming back to this is exception 1. Now, the first exception, why are we saying exception? Because they are exceptions to murder. And exception in the sense, it's not that a person will be led free. It is that this particular act of death will be called as culpable homicide, but not amounting to murder. A person will be punished. For sure, he will be punished, but it will be not amounting to murder. Now, coming to the first exception, if there is grave and sudden provocation. Now, if there's a grave and sudden provocation, then what exactly that grave and sudden provocation would mean? So, grave and sudden provocation is, for example, I'll take this example. There's a person named, I'll take example from these only, Krish, and there is Vaibhav. So I'm taking names from the chat. I'm so sorry. I'm taking your names. So there's a person named Krish and the other person is Vaibhav. And what Krish does, Krish is defaming Vaibhav and Vaibhav doesn't like it. So Vaibhav gets infuriated. He gets very angry and he loses his self-control. Now, in this situation, Krish and Vaibhav are actually sitting next to each other and Krish is defaming, insulting Vaibhav. Now, Vaibhav is infuriated, he's angry, and he loses his self-control. And because of this, Vaibhav attacks Krish. Now, what kind of provocation did Krish give? Like example, Krish says that you cannot fire a gun at me. You do not have that much of willpower to do that. And Vaibhav, out of provocation, he actually shoots at Krish. So over here, if Vaibhav wants to say that I am taking or I'm resorting to the offense of culpable homicide not amounting to murder, then what does he has to prove? He has to prove first that there was a grave provocation by Krish. Second thing, the provocation was sudden. Sudden in the sense he said and I acted there and then. Third thing is he also has to prove that whether the provocation was directed to him only or was it directed to someone else. So if the provocation was directed at him and he's able to prove that he lost his self-control, then he will be definitely liable for the death, but under culpable homicide not amounting to murder. Another thing that I would like to point in this is you always check in these cases that who is the person who is provoking. So the person who is provoking, that person's death we are talking about. If someone else's death is caused, like for example, Krish has a son, and Krish, who should I make your son? Okay, I will make this person X as Krish's son. So Krish has a son, and Vaibhav, out of all the infuriation, out of all the anger which Krish has provocated, he thinks, let me kill his son. So over here, if this particular just in my order, yes. So if this particular case, if Vaibhav kills this person X who did not provoke at all, then this will lead to murder. Why murder? Because we are always saying that the provocation, the death or due to provocation should be of the person who has provocated. If someone else has been killed intentionally, then this will amount to culpable homicide amounting to murder. Now, talking about other case, like what if someone is killed accidentally? Like Vaibhav takes out his gun and he points at Krish that today I'll be killing you. And as soon as he points at Krish, Krish moves side and there's someone, a passerby who is going on the road, he is being killed. Now, if someone else is being killed due to mistake or because of such particular accident, then also this will lead to culpable homicide not amounting to murder. Okay? So it will not amount to murder, but it will definitely lead to culpable homicide not amounting to murder. So this was one example, and the landmark judgment, which most of you must be knowing about, the Nanavati case. If you are not aware, then that case was the Rustam movie, which was based on. You can take that. So the Nanavati case, that was the landmark judgment, wherein the court said that if a person gets a time to cool down his provocation, then that will not be culpable homicide not amounting to murder, but it will actually be a murder. Why? Because it says grave and sudden provocation. So sudden is, at that time, it should be a sudden, there should not be cooling period. Second thing is, if a person is voluntary sorting after the provocation, then that deliberate sorting after of provocation will not be considered. Okay, that kind of provocation will not be considered as valid provocation. Second thing is, if there's a public servant who is acting under a particular law, as per his duties he is following, and then you act or you say that that public servant has instigated me or provocated me, then that is not a valid defense. So for example, a police officer comes to Weber and says that, Weber, we are arresting you hereby. So over here, Weber should not be provocated by the fact that the police officer has come to arrest him and performing the duty. So over here, we say that if a public servant is acting, then that particular act will not be considered as provocation. The third thing is, if a person is acting in self-defense or private defense, and that act of self-defense or private defense will not be considered as provocation. Yeah, he or she is acting in self-defense because of your first act, not because of her or him. So this was the first thing. Now, talking about the further things, that is, culpable homicide will not be murder if the exception 2 points out that if it is in the exercise of private defense. But how do we define that? So we define that there's a person named A, okay, and there's a person named B. A looks from his window that B is approaching A with lathi in his hand. Now A is too scared that B will approach him and A might die or suffer some kind of injury. So what A does, before B actually comes inside the house, A takes out his gun and shoots at B. So over here, what we are considering is, this exception says that if there's a private defense and a person who has acted in his private defense, he exceeds the defense which is actually required, then he will be held liable for culpable homicide amounting to murder. Sorry, not amounting to murder. So if a person exceeds his private defense, then that person will be held liable for culpable homicide not amounting to murder. But there are certain things which we have to look upon, is that, for example, first you look upon whether there's a good faith, that the person A is acting in good faith or not. Second thing, good faith in the sense that whether he has any malicious intent to kill that person B or not, or he's actually defending himself. And the second thing that you check is that A has a right to private defense and he's exceeding the same. He is overpowering the power that he is having, and because of his exceeding, the other person dies. Now, the another thing that you refer in this, remember when I'm referring to this, every essentials have to be satisfied. Okay, so I'm referring to good faith, right to private defense. The word uses and, so it means you need to read everything together. And then it should be the next assumption is that A should not have pre-planned that B will come and then I will hit him with the gun. So there should not be any pre-plan, and it should be without intention of doing more harm than is required. So just A acts, but by chance the person dies and A exceeds his right to private defense, then this will be a culpable homicide not amounting to murder. Um, so over here, I can give one example. I have already given one example. I'm not going in much into examples now. So next is culpable homicide will not be murder. The exception 3. Now exception 3 is exception 3, it says that an act done by a public servant or in aiding for a public servant. So we'll take one example. So there is a police officer. Okay, there's a police officer, and there is another person named X. Now, police officer is a public servant, and this public servant, or if there is any other person who is helping this police officer, this public servant, we'll take them in the case. So, this police officer is has caused the death of this person named X. So when do we say that this will be culpable homicide not amounting to murder is that if a public servant in advancement of justice, he exceeds his power. He exceeds his power which is given by law, and he causes the death of the other party, and that too in good faith. So if death is cause of the other party and police officer is discharging the duty which has been caused, and there's no ill will which is there, he's acting in good faith, there's no ill will, and police officer exceeds the power which are given by the law, then he will be held liable for culpable homicide not amounting to murder. But there are many times a question that arises is, what are the fake encounters that are there? You read lots of quick cases relating to fake encounters. So in these kinds of fake encounter cases, it's always the fact that somewhere or the other, the duty is the duty of the police officer is to arrest a person, produce him before the court, and to safeguard a person. So over there, if a police officer is exceeding this particular duty and excluding or exceeding the power which has been granted, so that will be amounting to murder. Why? Because there was an ill intention. There was no, what should we say? There was no good faith which is involved. So if there is a fake encounter kind of thing, always remember whenever you are reading now, this is culpable homicide amounting to murder. Okay, I've written this short form. CHNM means culpable homicide not amounting to murder, and on the other hand, it is culpable homicide amounting to murder. So this is one example. If you want, you can read this case of Dukhi Singh versus State also, AIR 1955. ALL, it means Allahabad. It's an Allahabad High Court judgment, and 379 is the page number. Okay, now coming to the next case. The next exception wherein we can say it is not culpable homicide not amounting to murder is in case of a sudden fight. Now remember over here, we are not talking about provocation. We are talking about sudden fight which is there. Sudden fight, like there are two individuals who come and who fight with each other. We are not bothered as to who started this particular fight. But what we are bothered is that there's a sudden fight without a premeditation. As in, there's no pre-planned fight which is there. There's nothing premeditated. But the fight occurs between two or more parties, and none of the parties are taking undue advantage of the situation, or the act should not be cruel or unusual, which is not usually resorted to. So in these kinds of cases, we will say that this particular murder or this particular act, not murder, I'm sorry, this particular act of causing death of the other party will be called as culpable homicide not amounting to murder. I'll give you an example. Like the first case is A. Maharaja versus State of Tamil Nadu. Over here, there was a person named A. He had a farm, and B was another person. So in this farm, there were huge trees which were growing. So B one day, he took an axe and he started chopping these trees. A came over there and said, how can you chop off my trees? And who gave you the right to chop off my trees? B said, I'll still chop the trees. So they both engaged in fight with each other. As a result of which, A always used to carry a gun and A shooted B. So over here, there was a fight between them, and there was a sudden fight. We are not bothered as to who started the fight, whether A or B, not at all in concern. But what we are concerned is there was a sudden fight. It was not pre-planned. Second thing that I'll go again over here, just a second. It says the sudden fight, first essential fulfilled. Second essential is the offender should not take undue advantage of act in a cruel or unusual manner. So if you see whether this act is proportionate, B is merely cutting the trees. A would have called the authorities. A could have just took away his axe or done something else. But the proportionality is much greater. So if the act is not proportionate, and over here A took out his gun, we can say it's more unusual, it's more cruel. Therefore, A will be held liable for murder. It will be culpable homicide amounting to murder. Another case. Okay, so this was example wherein it's not falling under this exception. I'll give you another case. Another case is there were two parties who were fighting. The case is Dharman versus state of Punjab. So there were two persons who were fighting. They both had weapons in their hands and they started fighting with each other. And eventually, when we are saying a person should not get the advantage over the other. Now, both parties are having equal amount of weapons or the equal gravity of weapons and they are hitting at each other. So over here, if there is a mutual fight which is going on and there's no person who is taking advantage of the other, and in this particular fight, a person dies in between, then this will be called as culpable homicide, not amounting to murder. Why not amounting to murder? Because there was no undue advantage. So there's one of the questions in the chat box which says that why can't this be sudden provocation? Okay. Now, sudden provocation is there's one party who is provoking the other party. Okay. Now over here also there is provocation. But after this provocation, there is a sudden fight. So what if I just have to explain. So this is how where the provocation is lying and this is how a sudden fight is lying. Provocation can be due to fight or an act of the other party, and provocation can also be by just if someone is saying to you anything, or if there's an act like Nanavati case, if you remember the Akshay Kumar movie Rustam, it was just by an act a person got provoked. Whereas in this particular exception number 4, there's an actual fight which is there. So we are not categorizing this totally under what's called totally under the heading of provocation. Okay, we are putting this under the heading of sudden fight. And yes, see, when I'm saying there's one more question in the chat box. It says that so fighting with a weapon is not wrong. Okay, fighting with a weapon is itself is wrong. So I'm not arguing that you are allowed to fight with a weapon or a talwar or a sword, anything else. But what we are more concerned about when such a fight is going on with weapons, with deadly weapons, and both parties are equally placed. Well, like in the previous case which I gave, one person was having a lathi and the other person was having a pistol. So over here, one person is having undue advantage of the other, and there's a possibility that that person will act in a cruel or unusual manner. Okay, so the last exception that we will be dealing with is exception 5, and it says that death caused to a person above 18 years of age with his consent. What is the key point over here? With consent, that a person is freely saying that I want to die and please kill me. So over here, if a person is put to death, and that person who is being put to death, he or she has consented to the death, then this will be amounting to culpable homicide, not amounting to murder. I repeat again, if death is caused of a person and that person has consented for the death, then this will amount to culpable homicide, not to murder. There are many, yes, like many of you are pointing out, euthanasia. Now, in these cases of euthanasia and all, if you read the latest judgment which is there, it says that passive euthanasia is allowed, but not the active euthanasia. So if in case of active euthanasia, you'll be again held liable for culpable homicide not amounting to murder. If you go into why it's said as not amounting to murder, and why is it not called as murder, it said that it's a nobler thing to kill a person who is about to die. Maybe we won't go into that discussion, that jurisprudential discussion, but this is what is called as culpable homicide not amounting to death. I'll take one case. Take one case in the sense, the case is Dashrath Paswan versus State of Bihar. This is a Patna High Court judgment. There was a person named A. A person named A, and this person A failed twice in his 10th exam, and he was too depressed to have failed twice in his 10th exam. So he went to his wife named B and said, I have failed twice, I don't feel like living. So B said, you do one thing, you kill me and then you also die, let's both die together. So A said, let's put an end to our lives. So A kills B, and as when A was about to kill himself, police came in and A was stopped from committing a suicide and killing himself. So over here, if this person B is being killed, B is a major, she is a 19-year-old person, and she is being killed by the other person, but she has also consented for the death. So over here, when we are talking about the consent of the other party, so A will be held liable for culpable homicide not amounting to murder. So another thing is, when we are looking upon one of the questions in the chat box is whether suicide is an offense. Yes, suicide is an offense. It's a punishable offense under IPC. So this is the case with exception 5, and I give you example of euthanasia also. Now coming to the last thing. Now when we are discussing about the punishment, usually it's not asked in exam, but still like exam like CLAT and SLAT, but definitely in further exams. But still, for your knowledge, I am telling you that whenever a case is filed, whenever an FIR, not case you leave, whenever an FIR is filed, a charge sheet is made. In that charge sheet, the section of punishment is written thereon. Punishment. So, for example, if you have seen many movies, it says Dhara 302 ke tehet फांसी की सजा, something like that. Like under section 302, a person is held liable for life imprisonment or for death. So when we are saying murder is under 300, so why are we bringing this section 302? We are bringing this because in all the IPC, like all the provisions of IPC, when a charge is framed or when a judgment is being decreed, at that time, the punishment section is being considered. And we say that a person is held liable under this particular section 302 or 304, whatever the case may be. So, just for your knowledge, for section 302, the punishment is life imprisonment, and in certain cases, like if there's a heinous crime which is committed, then like the manner in which it is committed is too grievous, then in all these cases, like punishment for murder, it says that I read that line for you, whoever commits murder shall be punished with death and or imprisonment, death or imprisonment for life, and shall also be liable for fine. So whenever you're reading of Bear Act, always be cautious about the words or and. Okay? So over here, the word and is being used. It means that along with death, the person has to pay the fine. And where does that fine goes? To the government. Okay? At least for these murder cases, not to the parties. The parties receive compensation. And over here, it's talking about fine. And in case of even 3 or 4, that is the punishment for culpable homicide. It also gives both death and even to imprisonment. But what is the extent of both? I'll read that for you. Punishment is imprisonment for life or imprisonment for 10 years and fine. And if it's again aggravated, then imprisonment for 10 years. Okay? So over here, we are not talking about death sentence, but over here in 302, we can also, like, not we, the judiciary can also give death sentence. So I usually test my students whether they have understood or not. So if Aditya sir, are you here online? If you can put this in the chat box, I will start the polling. And
Sure,
those
sure.
yes, you can just copy. Should I copy this? Just a second. I'll copy the link and put in the chat box.
Correct.
Yeah, just a second. You can't see the chat box now. I'll stop sharing my screen. Question and answer. I'm sorry, sir. I can't see the chat box.
It's right below you.
Okay, okay, I got you.
Can you see it?
Yes, yes.
Yes, yes. I'll just post it. Just a second.
Okay, there's a question in the chat box. What if child dies during the process delivery naturally? See, if it dies naturally, it's no one's fault. Okay, so many questions. Okay, I've started the poll. You can also scan this QR code. Let me check who all gets the answer. It's 21:56. I'll stop in 1 minute. Okay, Abhishek, you have a question. By that time, I also solved the questions. Abhishek has a question. What is the punishment for the murder which is done for self-defense? But there is no punishment. It's called as exceptions. In the initial slides I taught you, there is some lawful homicide. For a lawful homicide, there is no punishment at all. It's exempted. Refer chapter 4, section 76 to 106, if I'm not wrong. Nothing is left. Okay, so I am stopping. Now let's see. Okay, I've stopped the poll. Let's see. So, okay, so this will be not amounting to murder. Why? Because it says Z attempts to horsewhip A, not in such a manner as to cause grievous hurt to A. A draws a pistol, Z persists in the assault, and A, believing in good faith. See, I told you, whenever you're referring to such kind of cases or such kinds of fact, always refer with this law point which has been given. So the keyword over here is good faith. A, believing in good faith that he can by no other means prevent himself from that horsewhip. Like horsewhip is like a person is whipping and he just want to save himself. So over here, there's a private defense. Second thing is, like, you can save yourself from the horsewhip, or you can move aside, you can hold, or you can put some other thing, like you can take some other tools which are lying aside you. But drawing a pistol and killing that person, there's no proportionality. It means that you're exceeding your private defense. And if you're exceeding your private defense, then what does it mean? That you have committed culpable homicide, not amounting to murder. Okay, so yes, so I have 31. Okay, now 32, it's increasing. So 32 voters who have said that it's not amounting to murder. Very good. And there are other students who are saying that it's no offense, it is an offense, but chalo. So I hope it's clear. I was clear enough, and I was not rushing through. Aditya sir and Daksh, I am done with my lecture for today. I'll stop sharing my screen.
Thank you so much, Garima. It was so lovely to hear you. And such a humbling experience for us as well, just to know about culpable homicide and murder. I'm sure all the kids have gained a lot from the session. Guys, just like Garima ma'am, we will be having a series of lectures. So we will be engaging a lot of professors from various law schools. In fact, I'll share my screen and quickly tell you about our plan. So I will request you guys to stay for just a couple of more minutes, and then probably you can go and have your dinner. So of course, you know, IMS Law is now IMS Get Set Law. We have three basic properties: ignite, incite, and initiate. So when it comes to ignite, we have a talk show series wherein we invite prominent lawyers, judges. In fact, Allahabad High Court former Chief Justice is about to come on our show probably sometime in January. So you will have an experience of interacting with him as well. In Insight, right now, because everything is happening virtually, therefore we are inviting students from prominent law schools, and as a part of this series, we have invited Garima ma'am as well, who taught us tremendously well. And then we have Initiate, wherein we take care of all the academic fulfillment, all the things related to your law entrance preparation. For those of you who have not joined IMS, there are a lot of batches which will be soon, getting launched. So these are the batches which will be soon be launched. So 22nd December there's a batch, 26th December there's a batch for people who are repeat takers. There's a batch on 2nd November as well. And then of course you can follow us on Telegram, YouTube, Instagram, Facebook. It's just that you'll have to write on Telegram our IMS GSL channel's name. On YouTube, you are already there. I suggest and rather request you to subscribe to our YouTube channel. A lot of interesting things are going to happen. And Instagram, of course, we are coming up with a few posts, but it's not that active. But still, I would recommend you to follow us on Instagram and Facebook as well. So that's it from our end. I would like to thank Garima ma'am again. It was so wonderful just to see how she speaks, just to see how she explained everything to all of you. And I'm sure all of you have taken a lot from this session. A lot of you guys were asking how to stay in touch with Garima ma'am. So you can, we will share her email ID with you guys on the GSL channel as well. So there you can drop her email, and then you can communicate with her. Thank you so much, Garima ma'am. If you can
Thank you so much, sir. It
hear
was
me.
a wonderful experience over here. Thank you so much.
Right. All right. Thanks a lot. Take care. Bye.